Alright, so let's read some Colorado laws. This comes from Article 71. This is 1371-101. Short title is Colorado Uniform Jury Selection and Service Act. So when you go to select a jury, it's got to be a fair jury. 1371-102 definitions as used in this article unless the context otherwise requires. 1. Clerk and clerk of the court include any deputy clerk or the jury commissioner. 2. Court means a district or county court of this state and includes any judge of the court. 2.5 Juror service means the period of time during which a person is committed to serving upon a jury from the time the person reports and checks in on his or her designated reporting date through until he or she is released by the court or by the jury commissioner. Jury service includes any time that a person spends in the jury selection process and any time that a person spends in a trial. Juror wheel means any electronic automated system for the storage of the names or identifying numbers of prospective jurors. Master juror list means the voter registration list for the county, which shall be supplemented with names from other sources prescribed pursuant to Section 1371-107 in order to foster the policy and protect the rights secured by this Article. 5. Master juror wheel means the juror wheel in which are placed names or identifying numbers of prospective jurors taken from the master list. 6. Voter registration list means the official records of persons registered to vote in the most recent general election. So, clerk of the court also includes deputy clerk or the jury commissioner. That's interesting. It doesn't say clerk and clerk of the court are a bunch of fucking assholes that fuck you over the moment that you report a crime. Oh, you're a citizen and you're reporting a crime? Well, we're just a system and we're not here to help you. We were here to fuck you over. What, you're a victim? Oh, we don't care about victims' rights. That's interesting. Alonzo Payne gets recalled for not giving a shit about victims' rights, but I've had 12 felonies before September 17th, several felonies after September 17th, and not a single one of these motherfuckers have said shit about victims' rights. 1371-103. Number of trial jurors. A jury in civil cases shall consist of 6 persons unless the parties agree to a smaller number, which shall be not less than 3. Interesting. A jury in civil cases consists of 6 persons. So automatically, if it's a criminal case, you have a jury of 6. And so when the chief judge says, no, I'm not going to hear that, well, hell, he just cut your jury down from 12 to 6. And he, no wonder. Oh, okay, that's why Quintana didn't give a damn about crimes in Costilla County. Because that's the culture of the judges. Quintana doesn't care because Woods and Gonzalez doesn't give a shit. 1371-104. Eligibility for juror service. Prohibition of discrimination. 1. Juror service is a duty that every qualified person has an obligation to perform when selected. 2. All trial and grand jurors shall be selected at random from a fair cross-section of the population of the area served by the court. All selected and summoned jurors shall serve except as otherwise provided in this article or by court rule. 3A. No person shall be exempted or excluded from serving as a trial grand juror because of race, color, religion, sex, sexual orientation, marital status, national origin, ancestry, economic status, or occupation. 3B. A person with a disability shall serve except I, as otherwise provided in Section 1371-105, 1371-119.5, or 2, where the court finds that such person's disability prevents the person from performing the duties and responsibilities of a juror. C. Before dismissing the person with a disability pursuant to paragraph B of this subsection 3, the court shall interview the person to determine the reasonable accommodations, if any, consistent with federal and state law that the court may make available to permit the person to perform the duties of a juror. 4. The court shall strictly enforce the provisions of this article except that the Supreme Court may provide by rule for the exclusion in a criminal trial of a juror who is employed by a public law enforcement agency or a public defender's office. That was 1371-104. 1371-104. You don't give a shit about felony menacing, you hypocritical motherfucking pieces of shit. God damn, you don't give a shit about felony menacing. Fucking pieces of shit. 1371-105, qualifications for juror service. Any person who is a United States citizen and resides in a county or lives in such county more than 50% of the time, whether or not registered to vote, shall be qualified to serve as a trial or grand juror in such county. Citizenship and residency status on the date that the jury service is to be performed shall control. 2. A prospective trial or grand juror shall be disqualified based on the following grounds. A. Being under the age of 18. B. Inability to read, speak, and understand the English language. C. Inability by reason of a physical or mental disability to render satisfactory juror service. Any person claiming this disqualification shall submit a letter, if the jury commissioner requests it, from a licensed physician assistant authorized under Section 12-240-107-6, licensed advanced practice nurse, or authorized Christian Science practitioner, stating the nature of the disability and opinion that such disability prevents a person from rendering satisfactory juror service. The physician assistant, licensed advanced practice nurse, or authorized Christian Science practitioner shall apply the following guideline. A person shall be capable of rendering satisfactory juror service if the person is able to perform a sedentary job requiring close attention for 3 consecutive business days for 6 hours per day with short breaks in the morning and afternoon sessions. D. Sole responsibility for the daily care of an individual with a permanent disability living in the same household to the extent that the performance of juror service would cause a substantial risk of injury to the health of the individual with a disability. Jurors who are regularly employed at a location other than their households may not be disqualified for this reason. Any person claiming this disqualification shall, if the jury commissioner request it, submit a letter from a licensed physician assistant authorized under Section 12-240-107-6, licensed advanced practice nurse, or authorized Christian Science practitioner, stating the name, address, and age of the individual with a disability, the nature of care provided by the prospective juror, and opinion that the performance of juror service would cause a substantial risk of injury to the individual with a disability. E. Residents outside of the county with no intention of returning to the county at any time during the succeeding 12 months. F. Selection and service as an impaneled trial or grand juror. Selection and service as an impaneled trial or grand juror in any municipal, tribal, military, state, or federal court within the preceding 12 months, or being scheduled for juror service within the next 12 months. Any person claiming this disqualification must submit a letter or other formal acknowledgement from the appropriate authority verifying his or her prior or pending juror service. G. Appearance as a prospective juror in state court in accordance with the provisions of Section 1371-120 within the current calendar year. Any person claiming this disqualification shall submit a letter or other formal acknowledgement from the appropriate authority verifying such prior juror appearance. This exemption, however, does not apply in emergency circumstances as provided for in Section 1371-112. H. Deleted. 3. A prospective grand juror shall be disqualified if he or she has previously been convicted of a felony in this state or any other state, the United States, or any territory under the jurisdiction of the United States. 1371-106, jury commissioners. The chief judge of each judicial district shall appoint a jury commissioner for each county within that judicial district. Each jury commissioner shall be compensated as determined by the Supreme Court pursuant to Section 13-3-105, but no court employee who serves as a jury commissioner shall receive any compensation in addition to a regular salary. 1371-107, master juror list. 1. Each year, the state court administrator shall obtain from the Secretary of State a voter registration list for each county in the state. The state court administrator shall also obtain licensed driver list from the Department of Revenue, and where available, the Department of Revenue shall match said driver's license records with the most recent address of the individual used for income tax purposes and supply any additional income tax addressed to the court administrator. The state court administrator may obtain other list of residents of the state as necessary and desirable. The voter registration list as supplemented, as supplemented and modified by other lists may be used to compile the master juror list for the following year. A copy of the master juror list that does not contain addresses of the jurors shall be open to the public for examination as a public record. Any person, number 2, 1371-107-2, any person who has custody, possession, or control of any list to be used in compiling the master juror list shall furnish upon request a copy of that list to the state court administrator. 1371-108 Master Juror Wheel 1. The state court administrator shall use an electronic automated system to compile and maintain a master juror wheel. The wheel shall consist of names, addresses, dates of birth, identifying numbers, and jury histories for prospective jurors taken from the master juror list. Each year, the master juror wheel shall be emptied and refilled in compliance with the provisions of this article. Jurors receiving cancelizations or postponements of juror appearance and service may be replaced on the master juror wheel for the succeeding year and shall receive new summonses for their new dates in the succeeding year. What's the point of having a Michael Gonzalez or a Kim Woods? I asked them to be a judge, and they said, fuck you. Okay, so fuck you, you piece of shit. So because you put your head in the sand, because you closed your eyes, because you're helping to cover up the murder of Tecumseh, a felony, and subsequent fucking terrorism, drive-by shootings, fucking stop and goes, what you gonna do, spotlighting in an area where there's nothing but fucking crimes. Injustice anywhere is a threat to justice everywhere. You think they wake up and they say, oh my God, we're trying to convict him for felony menacing when he was being felony menaced beforehand and afterwards? We are such hypocrites. We better get on actually being good fucking people. We need a presence of justice in the community. We don't need to just protect our friends. We don't need to just protect a small clique of people while we fucking rape and fuck everybody else over. Is there two classes of people? That's what it sounds like. Some people can get arrested and other people can't get arrested because the rule of law says none of you assholes are allowed to go around murdering or raping or stealing or using violence. None of you guys can do that. That's the law in Colorado. I wonder if the judges know the laws of Colorado. They just making shit up. Article 2, Section 13 says you have a right to bear arms in defense of home, person, and property. I don't think Michael Gonzalez never heard of that. Michael Gonzalez has no idea about the Bill of Rights in Colorado. Michael Gonzalez, you have the Bill of Rights from the United States Constitution and the Colorado Constitution. Both of them. You have not just a right to speak, and it's law, so that's not a request. Hey, can I speak here and there? In court, hey, do I have permission to speak freely? Sure. But in the privacy of my own home, I'm allowed to fucking talk and post YouTube videos. And I don't want none of you rat bastards. I want Abraham and Oksana. My future son and daughter, to hear all the shit that I had to go through in order to make sure that they had a safe house and a safe neighborhood and a safe society to live in. (1371-109) Random selection from a master juror list. If all prospective jurors on the master juror list are not needed, the selection of the names or identifying numbers of prospective jurors to be placed on the master juror wheel shall be by a random selection method which ensures equal probability of the selection. 1371-110 Juror selection and summoning a juror commissioner shall specify the number of trial jurors needed for each day's juror pool or for selection of a grand jury within that commissioner's county. The state court administrator shall then randomly select the specified number of jurors required from the master juror wheel and shall issue a summons to each selected prospective juror, either personally or by mail, addressed to the usual residence or post office address of the prospective juror. 1371-111 Contents of juror summons. The juror summons shall state, number one, the juror summons shall state whether the anticipated service is that of a trial or grand juror, the beginning date of the juror service, the name, address, hour, and room number, if any, of the courthouse or office to which the juror shall report on the first day of service. The fact that a knowing failure to obey the summons without justifiable excuse is a violation of Section 18.8.612 CRS and a Class 3 misdemeanor punishable is provided in Section 18.1.3 501 CRS and such other information and instructions as are deemed appropriate by the state court administrator or the jury commissioner. 2. Every prospective juror shall also receive with the summons A. Notice of the qualifications for juror service, and B. Instructions to jurors for retrieving juror service acknowledgement information as described in Section 1371-132. 1371-112, emergency summonses. In order to meet emergency needs of the court, the state court administrator or a jury commissioner, by any means of notice, including notice of telephone, may summon additional trial or grand jurors to appear for juror service at a time certain, and shall inform the juror at which courthouse to appear. So that's interesting. If you don't have jurors, then you probably could just walk out of the courthouse. It says you could summon however you want to summon them. So you could just pass out, they said even by telephone, so you could pass out little pamphlets, right? Show up tomorrow. And I would think that, I don't know, I mean, if I needed to get a jury, I could walk out there and ask 50 people if they want to be a part of a jury. And since, if they don't, then okay, no. But if they do, and then it's up to the preliminary challenges. That sounds fair to me, because it's got to be a jury of my peers. And if the defendant literally chooses the jury pool, then it's going to be that's super fair. That's super duper fair. 1371-113, modification of juror service. In order to meet the urgent needs of the court, a jury commissioner may modify the date, location, or other condition of trial or grand juror service, and may notify the prospective juror the modification by telephone or other appropriate means. 1371-114, cancellation of juror service. Whenever it appears that the number of jurors scheduled to appear is in excess of the number needed, a jury commissioner may cancel the trial or grand juror service of a prospective juror, and may notify the juror by telephone or other appropriate means. Any juror whose service has been canceled is not considered disqualified under Section 1371-105-2F, but may be randomly reselected for further service within the succeeding 12 months. 1371-115, juror questionnaires. Number 1, on or before the first day of the term of the trial or grand juror service, each juror shall be given a juror questionnaire requesting the following information about the juror: name, sex, date of birth, age, residence, and marital status, the number and ages of children, educational level, and occupation, whether the juror is regularly employed, self-employed, or unemployed, spouse's occupation, previous juror service, present or past involvement as a party or witness in a civil or criminal proceeding, and such other information as the jury commissioner deems appropriate after consulting with the judges in the judicial district. The questionnaire shall contain a declaration by the juror that the information supplied is to the best of the juror's knowledge true, and acknowledgement that a willful representation of a material fact is a Class 3 willful misrepresentation of a material fact is a Class 3 misdemeanor punishable as provided in Section 18-1.3-501 CRS. Immediately below the declaration, the questionnaire shall contain a place for the signature of the juror. A notice that the completed questionnaire is not a public record shall appear prominently on its face. 2, unless the court orders otherwise, the jury commissioner shall provide copies of the appropriate completed questionnaires to the trial judge and counsel for use during jury selection. With the exception of the names of qualified jurors and disclosures made during jury selection, information on the questionnaire shall be held in confidence by the court, the parties, trial counsel, and their agents. Upon the completion of jury selection, the parties and their counsel shall return all copies of the completed questionnaires to the court for immediate destruction. The original completed questionnaires for all prospective jurors shall be sealed in an envelope and retained in the court's file, but shall not constitute a public record. If a person's answers to a questionnaire indicate that the person is disqualified or disabled from performing jury service pursuant to Section 1371-104-3, 1371-105, or 1371-119.5, or in the opinion of the court, state grounds sufficient to be excused from jury service pursuant to Section 1371-119.5, the person's name shall not be included in the juror pool, and the court shall notify the person that he or she is excused from jury service. 1371-116, trial jurors' right to one postponement. Trial jurors' right to one postponement. A trial juror shall have the right to one postponement of the term of juror service. Such postponement shall not last more than 6 months, but may extend into the next calendar year. To exercise this right, the juror shall notify the jury commissioner by telephone or in writing, requesting an alternate date to which the juror service may be postponed. A jury commissioner, in his or her discretion, may set the date to which the juror service is postponed. A jury commissioner shall notify the juror by telephone or in writing of the new date. 1371-116.5, postponement related to co-employee jury service. Upon notice by an employee, a jury commissioner shall postpone and reschedule the service of a summoned juror who is regularly employed by an employer with 5 or fewer full-time employees or their equivalent if, during the same period, another employee of the employer has been summoned for jury service. A postponement issued pursuant to this section shall not affect a person's right to postponement of jury service pursuant to Section 1371 116, 1371 117, assignment of courthouse location. Every trial and grand juror shall be notified on the summons or otherwise to perform juror service at a designated court location within each county. The jury commissioner or the court may permit a juror to serve at a different courthouse location within the county upon the finding that service at the original location would be a hardship. 1371 118, telephone notice. The jury commissioner or the court may permit a trial or grand juror to be available for juror service or continued juror service upon telephone notice. Such a juror shall provide the court with a telephone number at which the juror may be reached with certainty and shall agree to resume juror service if necessary not more than 1 hour after receiving telephone notice. 1371 119, deferments and excuses. Limitations. 1. It shall be the policy of this article that every trial juror shall be prepared to serve 3 trial days except as otherwise provided in this section or in Section 1371 104, 105, 119.52. The court or the jury commissioner may defer or advance the term of service of the trial or grand juror upon the finding as provided in Section 1371 104, 105, 119.5. The court may excuse a juror from grand juror service upon the finding of hardship or inconvenience, taking into consideration the length of grand juror service. The court may excuse a juror from trial juror service upon the finding of extreme hardship. The court may dismiss a trial or grand juror at any time in the best interest of justice. 3. The court, after a hearing, may excuse and discharge an impaneled juror prior to jury deliberation upon the finding of extreme hardship, and such discharge shall not be grounds for objection or mistrial as long as the statutorily or constitutionally required number of jurors remain able to proceed with the trial and deliberation. The court, after a hearing, may excuse and discharge a juror participating in jury deliberation only upon the finding of an emergency or for any other compelling reason. If the statutorily or constitutionally required number of jurors does not remain to hear evidence or to participate in jury deliberation after the discharge of a juror, the trial may continue with the lesser number of jurors only upon agreement of all parties on the record. The court may discharge an impaneled juror who has not appeared for jury service upon the finding that there is a strong likelihood that an unreasonable delay in the trial would occur if the court were to await the appearance of the juror. The court may exercise any authority granted in this section at any time before or during a juror's term of service. 1371 119.5, persons entitled to be excused from jury service. 1. The General Assembly finds and declares that it is the policy of this state that all qualified citizens have an obligation to serve on juries when summoned by the courts of this state unless excused in accordance with the provisions of this article. 2a, a person shall be excused temporarily from service as a juror if his or her jury service would cause undue or extreme physical hardship to him or her or to another person under his or her direct care or supervision. 2. The provisions of this subsection 2 shall apply notwithstanding the fact that the person does not have sole responsibility for the care of another person as described in Section 1371 105. 2d, be a judge or jury commissioner of the court for which a person was summoned for jury service shall determine whether jury service would cause the prospective juror or another person under his or her direct care undue or extreme physical hardship. C. A person who requests to be excused under this subsection 2 shall take all actions necessary to obtain a determination on the request before the date on which the person is scheduled to appear for jury duty. D. For purposes of this subsection 2, undue or extreme physical hardship shall be limited to circumstances in which a person, I, would be required to abandon a person under his or her direct care or supervision because of the inability to obtain an appropriate substitute care provider during the period of jury service, or 2, would suffer physical hardship, possibly resulting in illness or disease. E. A person who requests to be excused under the provisions of this subsection 2 may provide the judge or jury commissioner documentation that supports the request to be excused, including but not limited to medical statements, proof of dependency or guardianship, or other similar documents. The judge or jury commissioner may excuse a person if the documentation clearly supports the request to be excused. The documents comprising the documentation described in this subsection 2 shall not be deemed public records and shall not be disclosed to the public. 2.5. A person who is breastfeeding a child and is temporarily unable to or chooses not to leave the child in order to serve on a jury must be excused temporarily from service as a juror for up to 2 consecutive 12-month postponements. The judge or jury commissioner may request a medical statement in support of the postponement. A medical statement provided pursuant to this subsection 2.5 is not a public record and must not be disclosed to the public. 3. A person who is temporarily excused pursuant to this section shall become eligible for qualification as a juror when the temporary excuse expires as determined by the court. A person may be permanently excused only if the judge or jury commissioner determines that the grounds for being excused from jury service are permanent in nature. 4. The provisions of this section shall not apply to impaneled jurors or to deliberating jurors described in section 1371-119. 1371-120. Length of juror service. Trial juror service shall be for a 1-day term unless a juror is assigned to or impaneled on an incompleted trial when the 1-day term ends or unless the court orders otherwise. Nothing shall prevent a trial juror from serving on more than one jury or participating in more than one trial during the term, except that a trial juror whose deliberation ended with a verdict shall not be required to participate in a second trial even though the juror may not have completed the first day of juror service at the time of the commencement of the second trial. Jurors awaiting assignment to a trial shall be discharged as early as possible after it has been determined that their services will not be needed. Grand juror service shall be for a term of 12 months unless the court discharges the jurors earlier or enlarges such term upon the finding that the efficient administration of justice so requires, except that in no event shall a grand jury serve for longer than 18 months. 1371-121 Extended trials. Before a jury is impaneled, the court shall inform the jurors if a trial is expected to last more than 3 trial days and may excuse a juror from performing juror service in that trial upon the finding of hardship or inconvenience, taking into account the expected length of the trial. Any juror so excused shall otherwise complete the term of juror service. 1371-122 Failure to appear. Delinquency notice. 1371-122 The jury commissioner may send a delinquency notice by certified or first-class mail to any trial or grand juror who has failed to appear for juror service. The purposes of delinquency notices shall be only to notify the jurors of their delinquent status and to rectify the problem by appropriate means. The jury commissioner shall have discretionary authority to resolve delinquent juror problems. 1371-123 Enforcement of juror duties. The court shall take whatever action may be appropriate to enforce the provisions of this article upon the finding that a juror will not appear to perform or complete juror service or in response to the court's order. The court may take such action as is likely to compel the juror to appear. 1371-124 Delegation of authority to jury commissioner. The state court administrator or the court may delegate to jury commissioner such authority as is appropriate for the efficient administration of this article. 1371-125 Compensation and reimbursement. The compensation and reimbursement policy of this article shall be to prevent, insofar as possible, financial hardship for any juror because of the performance of juror service. Where financial hardship exists, the court shall attempt to place the juror in the same financial position as such juror would have been were it not for the performance of juror service. 1371-126 Compensation of employed jurors during first 3 days of service. All regularly employed trial or grand jurors shall be paid regular wages, but not to exceed $50 per day unless by mutual agreement between the employee and employer by their employers for the first 3 days of juror service or any part thereof. Regular employment shall include part-time, temporary, and casual employment. If the employment hours may be determined by a schedule, custom, or practice established during the 3-month period preceding the juror's term of service. 1371-127 Financial hardship of employer or self-employed juror. The court shall excuse an employer or a self-employed juror from the duty of compensation for trial or grand juror service upon the finding it would cause financial hardship. When such a finding is made, a juror shall receive reasonable compensation in lieu of wages from the state for the first 3 days of juror service or any part thereof. Such award shall not exceed $50 per day of juror service. A court hearing on an employer's extreme financial hardship shall occur no later than 30 days after the tender of the juror service acknowledgement information to the employer. The request for a court hearing shall be made in writing to the jury commissioner. To the jury commissioner. To the jury commissioner.